Good evening, everyone. Thank you so much for being here. My name is Barb Van Hoy, and I am a policy planning and engagement coordinator for the City of Colorado Springs Housing and Community Vitality Department. It's a mouthful. And I want to just remind you, if you didn't already notice, for those who are in person, we do have some snacks. Feel free to pick up the materials that are in the back. There is a stack of papers that says renters' rights, but then there's the red folders, and there is a renter rights packet in the red folders. So if you pick up a red folder, you can leave a packet for someone else. But those are also available on the city's website. So we provide information about these events, and we also have previous recordings and slides from previous events on the city's website at coloradosprings.gov/renters101. You can also there's a second page, which is /renter rights. We also have links to all of the many partners. And I just want to thank you for coming. Thanks to everyone online who's joining us. For those of you who are joining online, if you would please turn off your cameras, just because it will help cut down on distraction for other folks. We don't have a way of doing that from behind the scenes. So these events, the Renter Rights 101 classes, are really created because of a collaboration with many organizations in the community. Very special thanks to Colorado Legal Services and the Pikes Peak Library District, who do especially a lot of work on these. And the other partners who are part of this collaboration are the Justice Center, Colorado Housing Connects, the Colorado Economic Defense Project, the Independent Center, and Silver Key Senior Services. Before we hear from Attorney Clinton about the new laws around renter rights, we are going to hear from each of those organizations to give you a sense of what resources they offer if you or someone you know is looking for help around these issues. I have a little section on why we are here. I probably don't need to tell you that we have a really tight housing market. In fact, a recent study showed that in Colorado Springs, we have a housing shortage of close to 27,000 homes, apartments, or houses. And of course, in that situation, folks who are most vulnerable, when you find yourself in conflict, it gets especially more difficult. And so the city of Colorado Springs really wants to help residents stay housed as much as possible, reduce conflict between renters and landlords, really help everyone know what the rules are to keep as many of our residents housed as possible. So the format for tonight, as I mentioned, our collaborating organizations will share their resources. We're hosting 2 more of these events in 2024. We have one coming up on September 13th, which is at, I don't have it at the tip of my tongue. Well, you can see it, find it online. I think there might be a flyer in the back. September 13th, we'll have one in November as well. That date is still to be determined. If you would like to get more information about these, you're welcome to sign up for our newsletter, the Housing and Community Vitality Department. The sign-up sheet that's going around has a link where you can sign up for that, or you can also go to our website. So again, part of the City of Colorado Springs, if you go to Housing and Community Vitality, you'll find a link to sign up for that newsletter. And we'll also be sending out the recording of this event as well as the slides in that newsletter. Mentioned the packet. Okay, I am again really grateful for the partnership of organizations, and I want to invite Deb Hamilton from the Pikes Peak Library District to come up and talk about what the library offers.
There we go. All right, hi everyone. My name is Deb Hamilton. I'm with the Pikes Peak Library District. I'm the law librarian I have some of my business cards in the back. So if you have questions after this about how to find, copies of the law or how to get connected with other legal resources in town, please feel free to reach out to me. We do have some of this stuff on our website. If you go here to PPLD and then into research and then law collection.
That's actually sharing.
It's not.
Okay.
It's not. I can't share on Teams. Yeah, I don't
So she'll
think I
probably
have any
need your
control.
presentation. So anyways, I'll let them figure that out, but you can access our legal resources here. So I'm not going to take up too much of your time. I'm going to talk really quickly though about a second organization in town that offers free and low cost legal help. They're called the Justice Center. Their executive director couldn't be with us tonight. But I just want to tell you a little bit about their programs that they have available. And so let me get past this if I can. All right. So the Justice Center, as I said, they have both free and low cost legal help. If you go to their website under legal help and to find a lawyer, you can submit an application. They also do a weekly call-in clinic. So if you just want to call in and talk to an attorney for free, they do that every Wednesday night from 7 to 8:30 p.m. And the number to call here is 719-473-6212. And so again, that's every Wednesday, 7 p.m. to 8:30 p.m. 719-473-6212. They also have a service where you can email in questions at any time and get a written response from a lawyer for free. And that address, it's right here at the top. It's real small, so I'll say it a couple times. Justice Center, COS.org/email. And so again, that's Justice Center, COS.org/email. All right, I'm going to hand it back over to Barb.
All right, thanks, Deb. So we're going to do a little bit of technology switching around to make this work better so that everyone online can see a little bit better. So please, everyone, bear with us while we do that. But in the meantime, Ron, would you like to come in?
Absolutely.
We have Ron with Silver Key Senior Services.
How are you all doing tonight? The two ladies gave a great segue to what I want to talk about. How many of us just aren't too warm fuzzy on computers and cell phones? Great. That's a great segue because with Silver Key Industries, I'm a senior volunteer and we have classes free of charge that teach you how to navigate all this crazy thing called the computer and email and backslashes and HTTPs. And I'll get to the bottom first. How many people remember the old show Dragnet? Just the facts, ma'am, just the facts. The most important thing I can give you about Silver Key is this phone number, 844-2300. 884-2300. I'm sorry, 884-2300. Any questions you have about Silver Key? We have commodities, we have resource navigation, which leads right into what you're here tonight. We have companionship programs. We have rides. We have Meals on Wheels. Most people have heard of Meals on Wheels. Even if you haven't heard of Silver Key, we are El Paso County wide. We're only about 3 blocks down the road, right here behind Specialty Sports, 884-2300. Call them, say, hey, I need some help understanding my rental agreement. I need some help understanding what are all these papers I have to sign. We've been around for 54 years. We must be doing something right. All right. Commodities, or once a month, they bring a big box of food to your house, dry goods, things like this. Meals on Wheels, we have dedicated drivers, over 450 volunteers at Silver Key that deliver meals 5 days a week. We make sure you're covered during the holidays. I myself have 4 clients that I visit every week. We go fishing, we go to Bronco games. I've got a couple that's confined to wheelchairs, and one of them just hit an $8,400 progressive up at Cripple Creek. All right, so these are the things we do. Any questions? Again, 884-2300. Call them, say, hey, I'm needing some food. Hey, I'm needing a ride. Can you help me navigate this? Can you help me how to work out guardian papership? We have free tax preparation. And again, we've just set up a brand new hub where we're going to bring you in and we're going to start from how to turn the computer on all the way through this. So thank you for your time. Thank you, Barb.
Thank you, Ron.
You guys gave a great segue for what we wanted to do. So thank you very much.
Thank you, Parker. And next we have, I believe, Ruby, are you online with the Colorado Economic Defense Project?
I am. Hi,
Ruby's going to
Barb.
talk about what they offer.
Hi, everyone. My name is Ruby Lopez. I am the Director of Community Services with Community Economic Defense Project. So CDP for short. We work with the community with housing assistance and any resource connections that we don't have in-house. Pair you up with a resource navigator to connect you with other resources that we don't have in-house. But the ones we do have, I want to briefly introduce to you, starting with emergency rental assistance through the ERAP program or TRAG, the Temporary Rental Assistance Grant Program. With this rental assistance, it does require you not to have already been approved for rental assistance program within a 12-month period. But if you haven't, you are eligible. The capped amount is up to $10,000 upon approval. And it does require you to be in the eviction process with a summons or beyond. Another program that we have is our legal service through our law firm, CD Law, that offers legal guidance and representation to tenants facing eviction. Both CDP staff members and CD Law lawyers attend El Paso County courts twice a week to help file answers to summons and also apply for rental assistance in person. For El Paso County, CDP is there on Tuesdays and Thursdays. We also have resource navigation and digital equity team, similar to what Silver Keys provided with the digital equity piece. Ours is a little different. We find resources to partner organizations with other organizations that can offer needs to clients that we cannot help with. We also support clients with cell phone assistance. If you are in need of a cell phone, we provide a cell phone upon approval with 2 months of free service. This will help you get connected with any resource you need, any application process you also need to get connected to, as well as broadband referrals, transportation to RTD tickets to meet emergency transportation needs. And we also have a new program with towing assistance. If you've had your vehicle illegally towed, we can help with $60 or 15% of the cost upon approval, or reimburse you upon approval. You can also seek out legal assistance for a towing situation if you'd like. Another program we offer is benefit enrollments. We have a team set up to help you with SSI and SSDI applications and appeals, as well as to help applying for benefit programs such as SNAP, LEAP, Medicaid, TANF, as some of the examples. We have this diversion teams that pair clients with case managers and housing navigators to prevent homelessness and administer housing vouchers through the state. I've said so many different assistant programs types that you won't be able to remember, but the one that I do want to introduce you to is our call center. So if you want to inquire about any of these, we do have our care center. They manage the call statewide for rental programs as well as mortgage assistance programs. If you applied through the EMAP mortgage assistance program prior to the closure of June 7th, you can call our care center and have them connect you to any of these programs within CDP. And I will leave their information in the chat, but their phone number is 303-838-1200, 303-838-1200. You can either call or text. And lastly, another way to connect with us is visit us in person in Colorado Springs. We are located in the Family Success Center, and I will also drop the address in the chat at 1520 Verde Drive in Colorado Springs, room 151. With that, thank you for your time. I've shared some flyers also with Barb to share with everyone on these programs as a summary of what we can all connect you with. So thank you for your time. And I think it's still on mute on our end. We can't hear.
Can you repeat that number again?
Yes, and it's also in the chat. It's 303-838-1200.
Hey, Barb, put the mic on here.
The problem is I can't get into this on the. Use your fingers.
There we go.
What are those glasses again?
Okay,
Should be good.
all right, I think we're good now. Technology, thank you, Joe.
Of course. Thank you, everybody. Appreciate your patience while we sort through the IT stuff that this guy's not fixing for some reason, but okay. From the Independent Center, we've been here for about 36 or so years. We're a resource center, right? People around town know us as, you hear the word disability, people end up at our place. We get funding from the state because we have to do certain things in order for us to keep our doors open. And some of those things are advocacy. And that's something that I really wanted to share with you folks, because throughout the 3 years or so I've been there, and Aurora Soper's been there, who is my housing specialist. I've got Aurora here to answer all the hard questions. So, but throughout the years, a lot of the vouchers that we support at our Independent Center, right? We get a lot of phone calls from you folks is, can this person do this to me? Can my landlord do this to me? Can this person do this to me? I'm sorry, we didn't have those resources. But now we're excited to share with you that we have an actual advocacy specialist inside our building that we can now connect you folks on a one-on-one basis if you need to actually get some information that you can actually use. We're tired of referring you out, and then we don't get to follow up with you folks, how those conversations went. We're now able to provide advocacy and some resources internally for anyone that comes to us free of service. Everything we do is free of service. We provide independent living skills. Anybody who wants to come and, I don't know, learn how to speak Spanish, ride a bus, figure out the bus system, learn how to cook, you know, we provide those. We provide peer support groups, anything from a TBI group to a women's group to archery. Not kidding. We take a bunch of visually impaired people and we take them archery. It is fun to see. Rock climbing, we go to the movies. We also do something that might help some of you folks, home modifications, right? You end up at a place, you might need a ramp, a stair, some grab bars or something like that. We have our internal funding. We can help with that. We also have local partners that we partner with to help pitch in on that party, okay? Anything from assistive technology, right? My knees are giving out. I'm probably going to need a cane or a knee scooter. We provide that stuff. You guys have a story. We'd love to hear it. We'll be able to provide some resources, but we have an amazing housing department. Right now, we do not have a housing list open. We are maybe hoping for that opportunity, maybe around July timeframe, but for the last 2 years, we haven't. But even without getting new vouchers, we are supporting close to how many vouchers? 600 vouchers between 3 people. So we do a lot as far as helping individuals, whether if we're not able to provide you with that housing voucher you need, we have a lot of different partners that we can connect you with that can provide their housing resources. But really what's important that I wanted to share was our advocacy piece, because for years we've been hearing questions of, can this be done to me? How can I, navigate this part of this process? So we now can provide some answers, and we also, again, partner with local resources to be able to provide those resources for you. We're going to have a bunch of brochures and cards. We'd love to answer any questions you folks might have. We'll be around. Again, my name is Joe. I've got Aurora back there. First time listener, first time joining. This is exciting stuff. I'm looking forward to doing this again. Thank you all for the opportunity, and we'll be around if you have any questions.
Thank you, Joe.
Of course, Barb.
All right, and I see Patrick Noonan online from Colorado Housing Connects, and let's see if we can make the volume work again. I'm gonna turn this off.
Can you hear me okay?
Yes.
Okay, perfect. My name is Pat Noonan with Colorado Housing Connects. We are part of housing nonprofit Brothers Redevelopment. We offer a variety of different services, not only in Colorado Springs and El Paso County, but across the state. If you are somebody looking for affordable housing, dealing with a tenant landlord issue, facing eviction, looking for resources, interested in learning more about home ownership, maybe you're sick and tired of renting. Believe it or not, there are some programs out there in this expensive market to help get your foot in the door and still own in an affordable way. We have a lot of different services. All of them are free. Many of those are found on our website, especially our upcoming events calendar. I'll highlight a couple here for you. Next Tuesday on the 18th at 5 p.m., we'll have a credit workshop. So if you want to learn about how to build or improve your credit, you can patch in via Zoom and learn some more on Tuesday night. We'll have Colorado Legal Services also presenting a deep dive in on the eviction process. So if you want to learn about that on Thursday night, a week from today, that'll be at 6 p.m. We'll host a Colorado Springs homebuyer class in person coming up later in July. Those details will announce publicly shortly as we get some of the details squared away. But really, you can speak to any of one of our housing navigators for any resources you might need. We'd love to hear from you.
Patrick, you got muted.
You can visit us at coloradohousingconnects.org or call us at 844-926-6632, 844-926-6632. And for those joining online, I've shared that in the chat. Thank you very much.
Thank you, Patrick. I think finally we're ready for the main event. And he's got a lot of information to cover tonight, so I'm going to just turn it right over to Clinton Albert.
Sounds good.
And you're sharing, so you're all set.
Yeah, we're all sharing. We can set the camera. Or not. Evening, folks. My name is Clinton Albert. I'm an attorney with Colorado Legal Services. Tonight, we're going to be trying to cover most of the major legislative changes over the last 3 months. The eviction process changed drastically, and the ending of a tenancy changed drastically in April. In May, the warranty of habitability was pretty much done from the ground up again. All right. And last week, the Governor Polis signed into law new protections related to mobile home parks, tenants in home parks. Folks, we're not going to have time to get to the latest law. I know that some of y'all online or in person have previously submitted questions. I'm going to try my best to get to them, but we have a ton of information to get through tonight. Can everybody in the back hear me okay? All right. Everybody online, I'm assuming you can hear me okay. And if you can't, please let us know in the chat. All right. So just a few things to keep in mind. This presentation tonight's for informational purposes only. Housing issues, especially, prior to now, I always thought they required a thoughtful analysis of both the facts and the law. They particularly and especially require that now. So this is, as much as I would like to be able to provide that advice, this is not the proper setting for it because, well, I'd want a little more privacy, a little more confidentiality, and some time to investigate things. All right, so I just don't have that ability this evening. But if you are a low-income member of the community or a senior citizen and are facing a housing issue, you may contact Colorado Legal Services to apply for possible assistance in the matter. Our general phone number is there, as well as our physical address. Our website is coloradolegalservices.org. Oh. Okay. That's correct, yes. So what the projector, if the projector can project the teams projecting PowerPoint,
I'm not sure why it's not.
because that's not the shared screen. Right there, is that not what's being, can we project the screen? So that one, that right there. That's gonna take control for me. How do, where's the projector hooked up to?
It's up to this computer.
So yeah, we just need the projector to recognize that.
To show, instead of this.
And it should show whatever the teams.
Yeah.
Yeah.
So if it stops, but it says. It's.
It's because I'm sharing off this computer, not that computer.
It's still not going.
All right.
Hey.
Close
Oh,
that.
it's
Sure.
Close that all
I
together.
still can't,
Okay.
No, that's what I was looking for. Right there.
Yeah.
All righty.
just right now,
Just talking about the new laws, but everyone else is just like.
but they still just fucked up the video.
Mhm.
We
Yep.
haven't changed the
Now we're
landlord,
moving.
it's 2 months. Yeah, she
There
got
we
her
go.
nails done, so I gotta get it.
All
she's
right.
gonna- that's-
Okay, so thank you for your patience this evening, everybody. As you can tell, tech is not our specialty. This is. All right, so if you have general questions and about
Check.
laws that may still be in place, prior recordings may be able to answer those. But tonight, we're going to be covering two of the major legislative changes, and that's the cause required for the eviction of residential tenants and then safe housing for residential tenants. Those are the legislation, if you wanted to look at them, to read the full text of them. And then, like I indicated, we're not going to be able to get through everything tonight. This was a substantial one that Governor Polis signed last week. Parts of that are currently in effect. The remainder of it will go into effect June 30. So as of July 1, House Bill 24-1294, which we are not covering tonight, is going to be in full effect. All right, so and again, these are, I'm going to do my best to get us through all of the additions. There have also been subtractions, but we are limited for time and I'm trying to get as much information out to y'all as possible. So the first major change here is that cause is required for residential evictions. So if previously landlords were able to provide what's called a notice to quit, a notice to vacate, whatever it may be, and they did not need to have a reason for that. It could just be it's the end of your lease term and we're ending the lease. That has changed significantly. There are now limited reasons that a landlord is able to terminate a tenancy given the new laws that have just passed. All right, so this doesn't apply to everything and all tenancies. So it does not apply to short-term rentals, your Airbnbs, your VRBOs. It doesn't apply to employer-provided housing, mobile home tenants with equity in the home, whether the owner or whether they're on a rent-to-own, a lease-to-own, or if their lease agreement contains an option to purchase in it. These don't apply to tenancies where the tenant has not been living there for at least 12 months. So if you've been in your place for over 12 months, this is going to apply to you, unless we have a master tenant situation, which we'll get to in just a second. Tenants not known to the landlord to be a residential tenant. This doesn't necessarily mean squatter. Let's say it's a commercial lease and an individual's living there. There are going to be some kind of nuanced issues where that comes up. It's not just limited to squatters, which are also covered by a very different statute altogether. So a property where the owner or master tenant lives in the premises and the premises is less than 4 dwelling units. So single family residence, duplex, triplex, or a property where the owner lives in a property adjacent to the residential premises and we're dealing with 4 dwelling units or less. So this is where these new rules are not going to apply. So what is it, as we're kind of talking about the change, like I indicated, notice to quit was what was previously referred to in the statute. No reason at all, or no reason required. It could be for any reason or no reason at all, subject to the bounds of the law and fair housing. And then it also required different notice periods for the length of the tenancy. Now, notice to quit has been removed. The new definition of this is a notice to terminate the tenancy. There must be a reason, and that reason must be included in the notice. Also, that notice must now be a 90-day written notice. There are some exceptions that we'll touch on some of the issues, but for the most part, we are dealing with a 90-day written notice to terminate a tenancy, and there must be cause to do so. The reasons a landlord may terminate a tenancy: the pre-existing laws that have gone undisturbed. We've got non-payment of rent. You've got substantial violation, material violation of a lease. There are going to be some new reasons that we'll go over as well. But these are all kind of cause-based reasons to end a tenancy before the lease agreement, before the rental agreement. This is more applicable to the end of the rental agreement itself. So what are the reasons that a landlord may choose not to, or choose to terminate a tenancy? Well, there's the demolition or conversion of a residential premises. We've got substantial repairs or renovations. Don't worry, we're going to go through all of these in a little bit more detail, not speed reading them for fun. Landlord or family member of the landlord is going to move into the residence and assume occupancy. Where we have a situation where the place is going to be taken off the rental market for the purpose of selling it. Situations where a tenant refuses to sign a new lease with reasonable terms. History of non-payment of rent. So let's jump into what the reasons are here. All right. So the first one, demolition or conversion of a residential premises. You can see we've got a nice little single family home on the right that is now an insurance office. So what does this mean? So this occurs when a landlord plans to demolish a residential premises, convert it to non-residential use, or convert it to a short-term rental. So they can only terminate a tenancy under this if they provide a 90-day written notice, including a description and a timeline of the demolition or conversion of the premises, and a material demonstration of the proposed date when the project will commence. What does that mean? Building permit, application for permit, license to operate a short-term rental if we're in that theory here, and if the locale, if the jurisdiction requires a license for a short-term rental. So during this 90-day period, the 90-day notice period that is required, and again, this notice also has to be in writing. It has to be served properly as well. Emails still don't count for service. Text messages still don't count for service. Verbal still doesn't count. But during that 90-day period, the same terms and conditions are going to apply. And if you're allowed to stay there as a tenant through the end of that period to the termination date. All right, we've got substantial repairs and renovations. That is another one here. And this has some caveats to it, a little bit more than the prior rationale. So, but again, we're dealing with a 90-day written notice with the date to vacate the premises. This is not 90 days from the day this is served on you. This is X date. What's today's June 13th? So September 13th, roughly 90 days from today. It would say September 13th, not 90 days from the date of service. It must provide the tenant with an expected completion date and a general description of what these substantial repairs or renovation to the premises will be. And then landlord must proceed to commence those repairs, commence those renovations without unreasonable delay after the tenant moves out. If the work is expected to last less than 180 days, then the landlord shall provide the tenant with a notice including the expected completion date. This is pretty significant here, and this is a big departure from anything that has ever existed. Why is that? Because this notice now contains a right of first refusal, which means that if the tenant then responds to this notice within 10 days that, hey, we want to come back after this renovation is done, that sounds great to us, then the landlord shall offer that tenant the right of first refusal to sign a new rental agreement with reasonable terms. Now, likely that's not going to be the same terms given the work that's going to be completed, but the tenant will have the right of first refusal in that instance. If the tenant accepts the new agreement, then they have 30 days to move back into the premises. But if there's something that happens there, the parties can agree on an extended timeline. However, that agreement must be put in writing and it must be signed by both parties. Our exceptions here. So you cannot terminate a landlord cannot provide a tenant with a notice to terminate a tenancy for the purpose of substantial repairs or renovations if these repairs, these renovations are required to bring the property into habitability, into compliance with the warranty of habitability. Or if the repairs are initiated in retaliation against the tenant. Right, moving on, the next reason that is recognized is that a landlord or a family member of a landlord assumes occupancy of the dwelling. So if the landlord plans on moving back in, or if they've got a family member that plans on moving in, they may terminate the tenancy if the landlord or family member moves into the property within 3 months after the tenant moves out. The landlord provides 90 days written notice to the tenant, and there's no substantially equivalent unit that is vacant and available for occupancy by the landlord or landlord family member in the same building, not the tenant, but the landlord or the family member. And the landlord does not list the property for long or short-term rental for at least 90 days after the date the tenant is required to vacate. Of course, there are exceptions here. There are always exceptions. One of those is that 90-day notice I indicated. There is an exception to that. If the landlord's active duty military or the spouse of active duty military, then they only have to provide 45 days notice. Also, if the landlord or family member is a person with a disability, then that 30-day period to move in can be extended up to 90 days in order to make changes, make repairs to accommodate the landlord or the family member moving into the dwelling. All right, so we're not renting anymore, we're going to sell it. All right, so landlords are able to terminate a tenancy if they intend on taking the property off the rental market and putting it up for sale. When a landlord plans to sell a single-family residence, townhome, triplex, or individual condo, you do not see apartment building here. The landlord may terminate the tenancy if the landlord provides a 90-day written notice to the tenant. The landlord properly serves the notice upon the tenant. The rules of service have also changed. We will cover that as well. And then the landlord does not list the premises for long or short-term rental for at least 90 days after the move-out date. This is not a workaround to terminate a lease early. The lease is still the lease. The time agreed to is still the time agreed to. You can also provide a notice to terminate a tenancy, or as a tenant, you may receive one if you refuse to sign a new lease that contains reasonable terms. 90 days. So the landlord's has to provide 90 days of written notice after the tenant's refusal to sign the new rental agreement, and properly serves the 90-day written notice upon the tenant. The law does not tell us what reasonable new terms means. So I don't have an answer for that if that's your question. Okay. So one of them is one of the other reasons here, history of non-payment of rent. This is not the same as I owe rent money, because you can terminate it. You can file an eviction case where rent has become delinquent. That's a pretty common legal theory. But what does this mean in this context? So in this context, we're not talking about terminating a tenancy before the lease ends, but not renewing it. So if a tenant pays rent late more than 2 times during the term of the rental agreement, then the landlord may terminate the tenancy at the end of the agreement if 90 days written notice properly served, and the rent payment is late if it is submitted more than 10 calendar days after the day it is due according to the rental agreement. Not the day late fees may be charged, but the day that it may be due. The landlord provides the tenant with proper service of a written notice pursuant to statute. That statute there, that's the demand for payment. So it's not just that there's been a late payment. There's been a late payment, or there's been 3 late payments. There's been demands for payment that have been served. And if a payment is then submitted during the cure period, when you receive that demand, then it doesn't count. That's not a late payment. All right. So here's the new kind of form for the state has put out for the written notice to terminate tenancy. You can find this if you Google JDF. It's JDF 99B. You want to take that down. Of course, these slides will be provided and emailed out afterwards, so y'all will have a copy of this. All right, so the notice itself, we've kind of gone through the reasons. So what are those reasons? How do they translate into the notice? So the notice has to include a written statement. It has to have the legal basis. It has to have the factual basis for the no-fault notice to terminate the tenancy. It must also include a mediation advisement that if you receive SSI, SSDI, or cash assistance, there's a whole lot of statutes there, TANF, you may be eligible for mediation prior to your landlord filing an eviction. That is dependent on some other factors as well. The notice must include a specific description of the alleged no-fault grounds. For example, if we're thinking about a non-payment of rent, it has to have the dates. If we're saying there's a history, if there's three payments or more that have been late, you have to list out what those three are, at least. You have to list them out, because if that's incorrect, that would be a defense against this type of tenancy termination. The notice must be written in a language that the landlord knows or has reason to know is the primary language of the tenant. Sorry for that typo. But if your primary language is Spanish and your landlord knows this, notices in English are not going to cut it, because that's not putting you on notice of anything. So with these laws, what are the consequences? So if a landlord proceeds with an eviction for a reason that is not recognized, those reasons that we just went through, and the tenant loses possession without a court order, moves out on a written notice outside of these terms, maybe there's some kind of self-help going on, then the tenant may pursue a claim against the landlord for unlawful eviction. I've got the statute listed there, but just real quick, those penalties are $5,000 or 3 times the monthly rent, whichever is greater. All right, so there are some teeth on this law. New rules regarding written rental agreements. You can't modify any part of these reasons in a written rental agreement. Any attempt to do that, any attempt to waive that, that's void, that's unenforceable. You can't contract around the law. It's also a defense against an eviction for overstaying or holding over a notice to terminate tenancy, because if the landlord fails to follow the procedures that we just went through, it's not 90 days, it's not properly served, there are defects in the notice, or let's think, oh, you said you were going to sell it, but here's your listing for rent on Zillow 2 weeks later. Well, that's a problem, right? And then if the landlord cannot show that they complied with the new law, then the court shall dismiss the case. Landlords are not able to increase rent in a discriminatory, retaliatory, or unconscionable manner to get around the new law. That would likely come into effect on refuse to sign new terms. So if you're going to ask me what those mean, I'm going to tell you it's going to depend on the case, and I'm going to need to see the case. It's a case-by-case determination. All right, so now we're kind of shifting on to what are the updates to the evictions here. Unlawful detention. That's what has to be proven for there to be an eviction. That's the legal words. If you hear judgment for possession, that's eviction. Unlawful detention, that's the kind of court case that tries to get a landlord to that judgment for possession. So lease violations other than non-payment or substantial violations, that has been changed. Previously, it was other violations of the lease. Now the legislature has refined that, has narrowed that down to material condition or covenant of the agreement. Material is not defined by law. Likely have to wait for some cases to determine the scope of what Colorado courts are going to determine is material. All right, there's also a new basis for eviction based on quiet enjoyment or nuisance. So what this means is if a tenant has disturbed others or caused a nuisance, the disturbance or nuisance interfered with the quiet enjoyment of the landlord, others who reside in an immediately adjacent property, or other tenants or occupants who live in the same property. The landlord must live in the same property or an immediately adjacent property for this to apply to them. Right? So if they're living in another state, that doesn't apply. The tenant or the tenant has negligently damaged the housing accommodation, right? This is brand new. I have not even seen this come up on a demand yet. This went into effect in April, so I'm sure we'll start to see it kind of filtering through the courts and in cases in the near future. So the demand has to provide an opportunity to cure, meaning you have a chance to fix the problem. This is not a substantial violation, which is where you don't have a chance to fix the problem, but you have a chance to fix things, to make it right. The notice also, the demand has to contain a description of the specific conduct, not just you caused a nuisance, but this is what happened, right? You have to say what the problem is. You can't be vague about it. This is the roof over someone's head. You have to be specific. There are exceptions. So if a tenant's lawful exercise of its rights pursuant to any law or rule relating to the occupancy of the premises, that's not going to interfere with quiet enjoyment or constitute a nuisance. What does that mean? It's going to be case by case. I'd have to review it. If we're dealing with a situation where the quiet enjoyment, the nuisance is actually what we're hearing, what's disturbing us as other tenants or a landlord, if that's our tenant, if that's a tenant being the victim of domestic violence, and that's not going to be considered a violation of quiet enjoyment or the nuisance, all right? Again, here's the new demand. As you can see, down here, the effective date on these, they kind of list those. That says May 6th. So if you're watching this, if you're listening to this, and you are a landlord and you're looking at your forms, pay attention to the date on the bottom, because if you use old forms, that can trip you up and get you. You may just be starting over again real quick because it's not going to contain the required new elements from the new laws. So demand for compliance, like I said, this must include a specific description of the alleged violation, not just it's a violation. You have to say what happened, because if you're a tenant and you wind up in court and they're not telling you what happened, what are you going to defend against? You're not put on notice on what the problem was. Also, how are you going to fix it if you're not told this was the problem? It also has to have the date and time when the premises shall be returned to the landlord. Not 10 days from the date of service, date and time. A date's going to be, today's date is June 13th. The time right now is almost 6 o'clock, all right, 5:55. That's a date and time, not 10 days from the date of service. The demand must be in the language that the landlord knows or has reason to know is the primary language of the tenancy, of the tenant. All right, so also serving a demand, serving a notice, that has changed as well. All right. It may be served to a known tenant occupying the premises, or by leaving a copy with a family member above the age of 15. Service by posting, where it's taped to the door, that's still okay, but there must be at least one attempt at personal service on 2 separate days before it can be taped. So it's not you're signing a demand, you're signing a notice, you're walking up and you're taping it to the door. No, you're walking up, you're knocking. If no one answers, try again tomorrow. And then you can tape it if no one answers. Update to a mobile home right to privacy. This was in the cause required bill. If you're thinking, well, he just told us at the beginning, we're not going to touch on mobile homes. We're not. This is just one of the exceptions, because exceptions are my thing. And that right, the notice to enter a lot or a home for the purpose of repairs, it used to be a 48-hour notice. It's now a 72-hour notice. All right. We are about to get into the warranty of habitability. Before we do that, I'm going to check. No questions in the chat right now, so I'm just going to kind of push forward here. Hopefully we'll get to questions at the end. We still have quite a few slides to get through. So the purpose of the warranty of habitability, that's to promote public health by ensuring housing is safe and healthy for tenancies, and to protect and provide remedies for tenants who experience uninhabitable conditions. If anybody here has been at one of these before, you have heard me say air conditioners do not count. Guess what? Air conditioners now count. Air conditioners, swamp coolers, portable permanent cooling devices. Whoops, oh gosh. Uh-oh. Give me a second. I was betrayed. I hit the wrong button. Ah, man, I need to get to the Independent Center to take one of those tech classes because I am struggling, y'all. All right. So, air conditioner, portable cooling device. That's devices mounted in a window or designed to sit on the floor, which does not require permanent alteration to the residence. Also permanent, sorry about that, typo got by me there. Permanent cooling device. I don't know what calling is. I don't know what that is. All right. So that's now in there. All right. And it's also going to become more relevant as we go through things such as now things like extreme heat event are now included in the warranty of habitability, which we'll touch on in a few slides from now. Oh, look, right here. So an extreme heat event, that's a day on which the National Weather Service has declared, predicted, indicated a heat advisory, excessive heat watch, or excessive heat warning for the county in which the dwelling is located. Hotel room is now defined. That must be a room in a licensed or permitted commercial lodging establishment. Landlord now includes successor in interest, and it also includes the agent of the landlord. Maintenance service. This is a service provided at the landlord's expense for purpose of maintaining, inspecting, repairing, or ensuring the upkeep and preservation of a residential premises. This doesn't include one-time specialized skills to be brought in to do a particular service. But if you've got a general handyman, that's going to be maintenance service. That's going to really come into effect once we start getting to notice requirements and what constitutes notice for the warranty of habitability. Organizing definitions there. I'm going to keep moving forward here, but that's how the law defines organizing. Remedial action. This is the action that a landlord is required to take in response to a notice of an uninhabitable condition. And that means timely and good faith efforts to repair or remedy an uninhabitable condition at a residential premises or dwelling unit and to mitigate any negative effect of the condition. That last part's kind of new, all right? And if we think about it, it makes sense. It's not just go in and fix the problem. It's go in, fix the problem, and then repair the damage. A water leak, if we think, it's on the baseboards, we've now got some water damage on a wall, probably going to have to replace drywall. But again, that's not a hard and fast rule. I'm brainstorming out loud. Tenant now includes any member of the household who has a right to occupy the dwelling or any individual who otherwise has explicit or implicit permission to occupy the dwelling. Written writing in writing. This is also one of the biggest changes. Electronic notice, if you've heard me before, you've heard me talk about that. That's gone. We're done with electronic notice. We've simplified it. So any record conveying information in a form that may be kept by the sender and the receiver or can be displayed in visual text and can be retained. That's writing now. That's written notice. This includes paper. This is electronic. This can be digital. This does not apply to notice to terminate tenancies. This does not apply to demands for compliance. This applies to a notice for the warranty of habitability. Right? It's limited to this area. Right. By entering into the warranty of habitability is the promise that your residence is fit for a human being to live in, and by entering into a rental agreement, that is what a landlord is promising. And it is promising that it will maintain the habitability throughout the entire period that the tenant lawfully occupies the dwelling. Lawful occupation of a dwelling goes up through an eviction case up until a writ of restitution is executed. Breach of the warranty of habitability. And, so landlord breaches the warranty of habitability if the premises is uninhabitable by statute or in a condition which materially interferes with a tenant's life, health, or safety, and the landlord has not started remedial action within the required time period after having the notice, started to fix the problem, but didn't continue it until it was actually completely fixed, failed to completely fix it within a reasonable time after starting to fix it, failed to comply with requirements concerning damage from an environmental public health event. There's a lot of procedure for what happens if we have an environmental public health event, flash flooding, fires, things of that nature. And if a landlord's not complying with those regulations, those requirements, then that could lead to a breach of the warranty of habitability. Leased a dwelling which is uninhabitable at the beginning of the tenancy. Notice isn't required for this type of breach. If you move in and it's uninhabitable from the start. And at that point, the landlord's in breach because they made the promise when you entered into the rental agreement that your home was fit for human habitation, and you moved in and it wasn't fit for human habitation. Rebuttable presumption. This is going to be something we now see throughout the warranty of habitability. This is a big addition. Rebuttable presumption, I'm going to do my best to try to define this without using the words rebuttable presumption. I'm going to fail. But the presumption means this is something that we think happened. We're going to assume this happened. A court is going to start from that baseline. They're going to start from that baseline, but it can be disproven by the landlord. So a landlord is presumed to have failed to start remedial action, continue remedial action, complete remedial action if the tenant is able to establish that the dwelling is uninhabitable, the landlord has notice, and the landlord has not communicated with the tenant after having notice within the required time frame. When you submit a notice of the warrant for the warranty of habitability, your landlord has to respond to you within 24 hours after having receiving that notice as to the plans for moving forward. Not starting the remedies, unless we're talking about some very specific instances, but has to provide some kind of written communication. Or the condition continues to exist 14 calendar days after receiving notice if uninhabitable by statute, or 7 calendar days after receiving notice if the condition materially interferes with life, health, or safety. Like I said, that's rebuttable. This can be disproven if a landlord can show by a preponderance of the evidence that I started to fix the problem, but I couldn't completely finish it because there were circumstances beyond my reasonable control. To fix the problem, we needed to get into the dwelling, and we weren't allowed in by the tenant. They unreasonably denied entry into the dwelling. The tenant engaged in conduct that unreasonably delayed or otherwise prevented the landlord or the landlord's agent from starting the remedial action within the required time period, continuing that to completion, or completing it within a reasonable time period. A tenant does not have to prove the breach by a preponderance of the evidence. A tenant does have to prove the breach by a preponderance of the evidence. This presumption does not change that. Okay, it just is kind of the starting point for where a court's going to look at this issue. All right, so landlords have a duty to reasonably continue to make efforts to start or continue remedial action. These efforts are going to include prompt communication, correspondence, and good faith cooperation with the tenant, maintenance staff, contractors, government officials, or any other people that are going to be necessary to fix the issue. So, a couple slides ago, I said, well, the presumption can be rebutted if you can show that the delay was actually unreasonably caused by the tenant. So if a tenant denies entry to the dwelling when necessary to begin or continue the action, that timeline that's going to be paused until the tenant proposes a reasonable alternative date and time for entry, or the landlord proposes another date and time and the tenant agrees to that date and time. Notice, I've mentioned there have been changes to notice. There are. Electronic notice is deleted from the statute. That's no longer a thing. Notice is now any writing that provides the landlord to substantially know that the condition exists or may exist. What does that include? That includes written notice from a governmental entity regarding the conditions, think code enforcement. A third party regarding the conditions. The notice used to have to come from the tenant themselves. It no longer does. A tenant concerning a condition that may affect multiple tenants. We're thinking an apartment building and somebody's got an infestation. We've kind of on notice for all the contiguous units then about that because it may affect them as well. That it can be from the tenant itself regarding the condition, which is sent in a manner that the landlord typically uses to communicate with the tenant. If y'all text messages are fine. If you send messages on Facebook Messenger or X.com or Instagram, I guess that's fine too. I would just suggest not to do that and to do something more professional or something that's easier to really retain records of. This is a big one. If you've heard me before, I've beaten the drum and said, Maintenance requests are not notices of warranty of habitability. So let me correct myself now. Maintenance requests are now notices for the purpose of warranty of habitability. Written correspondence with maintenance staff or maintenance service provided by the landlord, including maintenance provided by a third party. There's that exception for the specialized folks. That's why in the definition part. But if you're submitting work orders, and they should reasonably put a landlord on notice of a breach of the warranty of habitability, you've provided a notice of the warranty of habitability. Make sure you keep a copy of that notice, though. That's going to be a big thing because you need to show that writing. Written observations or reports that the landlord has obtained personally, directly, or indirectly. I'm sure that could be any number of things, whether that's from a contractor writing up an estimate, maybe it's from code enforcement pointing out some issues. Maybe for some reason there was a police report and the police report indicates some damage to the property that would render the property in an uninhabitable state. Again, this is all new. So until the court says something doesn't count, it's going to be kind of a matter of first impression for a lot of judges and a lot of courts throughout the state. Any notice is sufficient if it is provided to the landlord in a manner that is required or permitted by the rental agreement or any property rules or regulations pertaining to the tenancy or residential premises. A lease, I've never seen this, but I suppose it happens. A lease clause that states a tenant may or must give verbal notice of a warranty of habitability issue waives all written notice requirements. And a written notice is valid if it substantially complies with all requirements of the warranty of habitability. It's not strict compliance. If there is a typo, if it's substantially compliant. And again, this is one where I'm starting to flounder because off the top of my head, I can't think of what that example would be. However, it doesn't require strict compliance anymore. There was a case that went up to the Supreme Court last summer regarding the warranty of habitability that ruled a tenant must strictly comply with the notice requirement. The legislature then turned around and said the notice is valid if it substantially complies. All right, so what needs to be done by your landlord, or what do you need to do as a landlord after receiving this notice of the uninhabitable condition, after receiving notice that there is something that makes this residence not fit for a human being to live in? Contact the tenant within 24 hours or 72 hours if the premises is inaccessible due to an environmental public health event. That communication must indicate the intentions to fix the problem, including when that repair is going to start and when it's going to end. Inform the tenant of the landlord's responsibilities, including the obligation to provide an alternative residence if applicable, and provide at least 24 hours written notice of entry if necessary to start or maintain remedial action. If the condition, the exception here, if we're talking about a life, health, or safety condition, or when there is an active and ongoing threat of causing substantial and material damage if immediate action isn't taken. There's a pipe burst and the water's now running everywhere. You got to get in there right away. Otherwise, things are going to get much worse. Entry for the purpose of starting to fix things. So on that notice, oh goodness, another typo. I'm sorry, y'all. You've got to say the date and time when you're coming in, right? Not, I'll be over in the next few days. I'll be over tomorrow, June 14th at noon. Okay. And you also have to kind of give a reasonable estimate of this is how long we're going to be there. Tenant may reasonably deny entry to the dwelling unit at the date and time the landlord requests entry, not when they receive the notice, but life happens. And if a landlord, if you show up to do the repairs and life has happened and your tenant's denying you, or tenant, if you're like, I am sick right now, I've got sick kids and we don't want to get everybody sick here, then you can deny entry. Landlords, you must then propose an alternative date and time, or as a tenant, you can propose an alternative date and time, and as a landlord, you can accept or reject that. As a tenant, you may permit entry with less than 24 hours advance notice. All right, alternative residence. There have been changes here as well. If we have a condition which materially interferes with life, health, or safety, or we have a condition that is a that is presumed to materially interfere with life, health, or safety. We're going to talk about what those are in a little bit. And the tenant makes a request. There's still a requirement that the tenant make an affirmative request. Then a landlord's remedial action fixing the problem must include providing a comparable dwelling unit or hotel room within 24 hours at no cost to the tenant. An alternative residence must include the same number of beds as there are used in the residence. If this dwelling unit is needed for more than 48 hours, then that alternative residence must also have a refrigerator with a freezer, a range stove or oven. You have to be able to make food if you're going to be there for 2 days or longer. Or a landlord must provide a per diem for incidentals and daily meals for each tenant in an amount at least equal to Colorado state employee per diem for intrastate travel. I don't know what that is. All right. So there are the alternative residence has a much more has more definition to it now. There are requirements that if you're in a 4-bedroom home, you cannot be, your alternative residence is not a hotel room with 1 king bed. Okay. If you're there for a week, you've got to be able to make your food. So the alternative residence, I guess we have to say this out loud. That has to be habitable too. You can't be moved from one uninhabitable residence to another uninhabitable residence. It also has to be accessible to individuals with disabilities. It must be located within 5 miles of the original dwelling unless the tenant agrees to an alternative more than 5 miles away. A landlord may select one 5 to 10 miles away if it is substantially less expensive than options within 5 miles. Or if there is not one available within 5 or 10 miles, then a landlord must select the nearest available comparable alternative residence. So while in the alternative residence, tenants remain responsible for the rent amount. Landlords are only required to pay relocation expense, are not required, landlords are required to pay relocation expenses for the per diem for meals that we discussed. Also, any reasonable costs incurred due to the relocation, including storage and transportation costs. All right. I'm trying to, for the storage costs, we've got flooding in a unit. We've got to go in. We've got to get some things out. So any furniture that's not completely damaged, that's got to be put in a storage unit. That would be a cost as a landlord that you would be responsible for. If you have folks that maybe they walk to work and school and now they need to take a bus, well, you've got to pay that bus pass. All right, hotel rooms now have limitations. So, and this is, if you want to think about this, you can be put up in a hotel room for 60 consecutive days. Okay. If the condition cannot be completed within that time period due to circumstances outside the landlord's reasonable control, then you don't have to keep kind of paying for a hotel room in perpetuity forever. All right. You can stop providing that hotel room accommodation in this limited circumstance if you determine the condition cannot be fixed within 60 days due to circumstances outside your reasonable control, and the landlord provides the tenant at the earliest opportunity a notice that states that specifies this problem can't be fixed within 60 days, specifies the date when the hotel accommodation will no longer be provided, and that the tenant may terminate the rental agreement without any liability, no financial penalty, and returns the full security deposit on or before the date on the notice for the end of the hotel accommodation. All right, record keeping, paperwork, everybody's favorite thing. Landlords shall maintain accurate and complete records of all written notices, sorry, a typo, and correspondence, and all documentation relevant to any condition or remedial action taken to fix a condition. You get notice, you got to keep that record. These records must be maintained and retained for at least 3 years after the tenant moves out. A landlord shall provide to the tenant, upon their request, any record, any notice, any correspondence of other documentation within 10 calendar days of the request. talk about the cost of repairs. Landlords are going to be responsible for the costs of remedial action so long as you receive notice and this wasn't caused by the tenant's misconduct. So if, as a tenant, if you, your guest, your invitee, somebody who you brought into your residence, made your residence uninhabitable, it's not your landlord's responsibility to pay for it then. Little carve out exception here on that front. If we're talking about the tenant being a victim of domestic violence, domestic abuse, stalking, unlawful sexual behavior, no, then it's uninhabitable. They're a victim in this situation. Environmental public health event. There's that slide. Sign the sheet, get the slide. I'm going to move on. You can also terminate your lease early if there's an environmental public health event. All right. This is in there as we've all seen the news of the flash flooding, fires, all the terrifying things. I mean, I lived through Waldo Canyon here, so that was just hoping that my house didn't burn down every day. So the slide's here. If you're facing this type of event, please reach out for legal assistance on that matter. Let's talk about mold. I hear some yes in the crowd. I know it. I know everybody wants to hear about the mold. Mold's associated with dampness in a dwelling unit, or it's any other condition causing the premises to be damp, which if it's not fixed, it could create mold, or it could materially interfere with the tenant's life, health, or safety. If you get a notice about mold, it's 24 or 72 hours, depending on the nature of the demand. 72 hours is if life, health, or safety is not indicated on the notice. What do you have to do for mold? Mitigate immediate risk by installing a containment, stopping active sources of water contributing to the mold, installing a high-efficiency particulate air filtration device to reduce exposure. I'm really sorry for my typos. I'll get a better copy off to Barb here tomorrow, hopefully. You have to maintain that containment throughout the entire process of fixing the issue. You've got to establish worker and occupant protections that may be appropriate given the condition, given the scope of the issue here. You've got to limit moisture sources and dry any and all impacted materials. You've got to decontaminate and remove any damaged materials. You've got to evaluate whether the property has been, whether the fix has been successful. How do we do that for mold? Test for mold. That's how you know if there is no mold. You test for it. I know mold's naturally occurring. There's going to be limits to that, which the testing companies will be able to assess. And then you also have to reassemble the premises to control moisture to prevent or to limit it from happening again. If the mold would interfere with someone's life, health, or safety, and they make a request, we are now in alternative residence land. There will be a comparable dwelling unit or a hotel room provided to the tenant at no cost. This is rental insurance. This is all new. Landlords shall not require a tenant to submit a claim with rental insurance to cover a cost or expense related to remedial action for an uninhabitable condition that the landlord is responsible for remedying. Landlords are prohibited from filing a claim with a tenant's rental insurance to cover the cost or expense that the landlord is responsible for, unless they have express written permission from the tenant at the time the claim is submitted, not after the fact, at the time. All right, what condition? I've said condition by statute, right? I always say kind of statute or life, health, or safety. So what conditions are subject to statute? These are additions. If you go through an older packet, you'll see what the kind of prior conditions. Tonight is more of a focus on what has been added, not what has already existed. So water, they've expanded the definition of this. Running water must be, you have to have that at all times. So running water at all times, hot water in an amount necessary for the tenant to perform all ordinary activities related to maintaining cleanliness and health. Got to be able to shower, got to be able to wash dishes, got to be able to make food. Infestation used to just be vermin, rodents. Now it includes pests and insects. Trash. It was just it used to be the appropriate amount of receptacles. Well, now there also has to be scheduled. Those appropriate amounts of receptacles have to be scheduled to be serviced and emptied at sufficient intervals to ensure containment and proper disposal of trash. Elevators must be maintained in good repair. Landlords have to comply with all radon requirements. Have to comply with all requirements related to the cooling devices. Or it's otherwise unfit for human habitation. This last one here, the otherwise unfit, that's a catch-all clause. If there's something the law didn't consider at the time, they've now given an opportunity for the tenant to provide notice of what they did not consider previously. The other conditions are still in effect. Like I said, these are the updates. This is January 1, 2025. Look at this in 5 months. All right. So that's for new leases and statements that are required to be in the new leases. All right. So rebuttable presumption time again, y'all. We've now the legislature has provided us with some guidance on what does it mean to materially interfere with a tenant's life, health, or safety. So if these conditions are present, the court is going to start from a baseline that, yes, this materially interfered with your life, health, or safety. Lack of waterproofing and weather protection for the roof, exterior walls, exterior doors, and exterior windows. And if you're thinking, hey, I remember that was a normal condition, it's this last part here. So that weather-related elements can enter the dwelling unit. I try to find some visual examples here. You see there's no window there. Yeah, that rain's coming in. That hail's coming in. Same with that busted roof. Any hazardous condition of gas piping, gas facilities, gas appliances, or other gas equipment for landlords to commence remedial action for gas-related issues, you have to hire a professional certified to do that. Inadequate running water or inadequate running hot water. The exception here is where there's a temporary disruption due to necessary maintenance, repairs, construction that is being performed, or temporary disruptions that a landlord could not reasonably prevent or control. Lack of functioning heating facilities and equipment fixtures that are installed and operating in compliance with applicable law at the time of installation. That's previously existed. So why is this now in life, health, or safety? That are maintained in good working order from October through April of each year when we need the heat. For that weekend in December or February where the temperatures don't go above 0 all weekend. So if your heat goes out, that's now presumed to materially interfere with your life, health, or safety. Any hazardous condition of electrical wiring, electrical facilities, appliances, or equipment. Lack of electricity or disruptions that are caused by the failure to maintain electrical wiring, facilities, appliances, equipment. For the electric, for the purpose of the warranty, for the limited purpose of the warranty of habitability, because I'm not speaking to any kind of regional building code or code enforcement, there's nothing that requires a specialization on that front. The specialization was limited to gas. Infestation of rodents, vermin, pests, or insects. Inaccessible fire exits in accordance with applicable building, housing, fire, and health codes. Thus, exit and egress are going to be synonyms. Missing, damaged, improper, or misaligned chimney or venting on any fuel-fired heating, ventilation, or cooling system. That's going to create a backup of some gases that none of us want to be exposed to, CO2, radon, etc., carbon monoxide. Inoperable elevators. If the elevator goes out when the tenant has a disability that prevents the tenant from being able to use the stairs, or the tenant relies on the elevator to access the dwelling, and there are no other operable elevators that provide access, we're materially interfering with life, health, or safety. And I've seen cases where it's an old building, and those old buildings have some exceptions on how many elevators they have, but the warranty of habitability does not grandfather them in. If you can't use the stairs and you're on a 3rd story, or there aren't any stairs, and the elevator goes out, well, you're trapped. So yeah, that's going to materially interfere with your life, health, or safety. So again, this is a rebuttable presumption, which means you can contest it. So by demonstrating clear and convincing evidence, that is a legal standard. Tonight is not the night for me to rattle off what that definition is. It is greater than preponderance of the evidence. It is less than beyond a reasonable doubt. It falls right in that sweet spot of absolute gray area. So this does not prevent a court or a jury from finding that any condition described materially interfered with the life, health, or safety. But this is a landlord being able to say, hey, court, I know you're starting from this baseline, but that condition didn't actually interfere with life, health, or safety. And here is my proof. This proof is clear and convincing. The clear and convincing is going to be what the court determines. All right, air conditioner time. Great. It's way too hot this week. Landlords shall not prevent a tenant from installing a portable cooling device unless the installation itself would violate building code, state law, or federal law. If it violates the manufacturer's written safety guidelines for the installation and use, if it damages the premises or renders them uninhabitable, or it requires more amperage to power the device than can be accommodated. If the landlord restricts installation or use at a premises with multiple dwellings, then the landlord shall prioritize a request for a reasonable accommodation for a portable cooling device over a regular request for a portable cooling device. When we're saying reasonable accommodation, we are in fair housing. So this is a tenant with a disability who's asking to enjoy the full use and benefit of their residence by having this portable cooling device. If you restrict it, you must disclose any restriction to a tenant or a prospective tenant in writing. Right? If you're showing a place, it's an older place, my place is from the early 1900s. It's not got the best electrical. So if you're told in writing, hey, the amperage here doesn't support, the electrical doesn't support this the amperage of this unit, then that would be a reason to restrict installation of an air conditioner. But if you're doing that, you have to provide information about whether the landlord intends to operate common spaces that will be cooled by a portable or permanent cooling device and available to the tenant during an extreme heat event. If there is not a common cooling space provided by the landlord, then the landlord has to provide information on community cooling spaces near the premises that are accessible to the tenant. What is a community cooling space? It means public spaces available to the tenant that are located on or near the premises and maintain a temperature not higher than 80 degrees. Think rec centers, community centers, public libraries, where we are right now. And there is an exception here, as you can see above that, not required to provide that information if they don't exist within 10 miles. So we're now into a section on remedies. What can a tenant do if the warranty of habitability is breached? Terminate the lease. So this has changed. It used to be 10 to 30 days on this issue. It's now 10 to 60 days. So you can, as a tenant, you can terminate the rental agreement without liability, without financial penalty. Meaning if there's an early, a lease break fee, that doesn't apply here. If the uninhabitable condition remains, by providing 10 to 60 days written notice, that notice must state the problem still exists. My place is still uninhabitable. I intend to terminate the lease and I intend to vacate the dwelling unit. And I intend to vacate on this day. It has to be a date. And that date must be at least 10 days after you give the notice. Otherwise, it's not a 10-day notice. You can terminate a rental agreement if the uninhabitable condition recurs within 6 months by providing the landlord with a notice within 30 days of that recurrence, of that situation coming back. And that notice includes 10 days written notice that the same condition has come back and the date that the tenant intends to terminate the tenancy. Again, that date has to be 10 days after providing the notice. Otherwise, it's not a 10-day notice. If the landlord fixes the problem prior to the termination date, the landlord and the tenant may agree in writing to take back the lease termination and continue the rental agreement. That is not an opportunity for a new rental agreement to come into effect. It is taking back the old one. Taking back the rescission and kind of resuming the old rental agreement that was in place. Rent deduction. Again, if anybody's seen me before, I've just kind of said, don't do this. It's now a nicer process. All right. So I now think I understand it. So I think it's actually usable. A tenant may deduct one or more rent payments from the cost of repairing or remedying an uninhabitable condition if the tenant provides 10 days advance written notice of their intent to hire a licensed or otherwise qualified professional to fix the problem. It may be a 48-hour notice if we're talking about a condition which materially interferes with life, health, or safety. This also can't be it's down here, but the professional that they intend to hire can't be related. It can't be family. After providing that 10-day notice, the landlord then fails to fix the problem within the time provided by the notice or fails to provide an alternative residence. Also, like I just said, the professional is not related to the tenant, and the professional provides an estimate that is reasonably consistent with industry standards for the remedial action. The tenant hires the professional to do the work, and the tenant then provides the landlord with a receipt, invoice, proof of payment for work completed within a reasonable amount of time after it's done, or provides that receipt to the landlord within 30 days of the landlord's request for the receipt. So they've streamlined the process. There used to be kind of competing estimates. Now we don't have that. Appliance replacement due to breach and rent deduction. So our fridge goes out. Instead of repairing the fridge, we can replace it and deduct that cost from one or more rent payments if the tenant provides 3 days advance written notice of the intent to purchase and replace the appliance. The landlord fails to sufficiently repair or replace the appliance within that 3-day period. The replacement appliance is of comparable quality and substantially the same features. Before I maintain this, I used to say, you know, if a smart fridge with a dumb little touchscreen, I can't have those. They're too nice. If that breaks and it's replaced with a normal fridge, it still does the same thing, right? So a landlord's not retaliating by replacing a refrigerator with a refrigerator. As a tenant, I don't think the law is intended if you have just a plain old fridge, no ice maker. If you go out and you buy a top of the line Rolls-Royce refrigerator, I don't think that's kind of what the law is intended to do here. Also, we're kind of outside of substantially the same features because we're adding all the bells and whistles on top of it. Also, you can't take it with you after the tenancy, so if you want to. Then, if you can't get it done, I'm not the legislature. I'm not the legislature, y'all. I'm just here to advise. I didn't write this. And yeah, I know that. Also, you know, and also the tenant must also provide the landlord with the receipt, the invoice, the proof of payment within a reasonable amount of time, or 30 days after the landlord requests this documentation. If a deduction is made over 2 or more rental periods, the tenants were only required to provide 1 notice of the intent to deduct rental payments. That does not mean that you can just deduct willy-nilly. It means when you provide that notice initially, and that cost is going to just kind of naturally flow into a second month, you don't have to provide a notice for that second month then. What about a wrongful deduction? All right, so the rent's been deducted, but it shouldn't have been. So a landlord may pursue any legal remedy available under the law for a tenant who wrongfully deducts by not substantially complying with the statutory requirements. If a court finds that the wrongful deduction was purposeful, then the court shall award the landlord damages equal to double the amount of money unlawfully deducted. We're kind of talking about a lawsuit for money. We're not really talking about an eviction here per se. The law used to state that on this purposeful wrongful deduction, that it was double the money and a judgment for possession. They've notably taken out the judgment for possession part. Yes. Okay. All right. Oh gosh. Folks, we may not get to questions tonight because I would really like to cover temporary restraining orders related to the warranty of habitability and injunctive relief. So you can file a claim. Claims or counterclaims for the breach of warranty of habitability. A breach of the warranty of the habitability is a lawsuit on its own. You do not have to wait for an eviction action to be filed. You can pursue actual damages. Actual damages include a reduction in fair market rental value during the period of uninhabitability. Tenants can also seek court costs, attorney fees. Punitive damages is new. That is a new and substantial addition to the statute, and any other damages is ordered by the court. You can also seek preliminary or permanent injunctive relief for a breach, including an order of specific performance. Meaning you go to court and you say, you get a court order that may say that the landlord has to fix the problem, and including fixing problems for other tenants that may be experiencing the same issue, in order that the landlord stop or modify practices, in order for the landlord to adopt policies, practices that ensure compliance with the warranty of habit. I'm not going to speed read. Court may determine actual damages at the time of the order or at a later date as deemed appropriate. If the landlord pays damages to the court and the tenant makes an application for the release, then the court immediately releases them to the tenant. If the tenant vacates the residence, the landlord shall not rent the premises until the unit is in compliance with the warranty of habitability. Temporary restraining orders. This is completely new. If you ask me, where do I get one of those forms? Contact the state. They haven't made them yet. A tenant may obtain an immediate temporary restraining order without notice to the landlord in court, which shall require the landlord to provide a habitable dwelling. Here are the requirements for that request. So if the court finds specific facts from the affidavit or a verified complaint or tenant's testimony that establish the following: dwelling is in a condition that materially interferes with life, health, or safety. Landlord has notice. Landlord failed to comply with warranty of habitability. The tenant certifies to the court in writing or on the record any efforts the tenant has made to obtain the landlord's compliance. Then the court may issue an immediate temporary restraining order. A court shall consider and rule on such a motion at the earliest possible time, and these motions take precedence over all other matters before the court except older motions for immediate temporary restraining orders. Okay, warranty of habitability is a defense against evictions, money-wise, non-money-wise. It's a defense against collections actions. This defense may be raised in an answer or a pretrial court filing. A court shall liberally construe a tenant's answer or other filing to determine whether the breach is raised as a defense. For example, you don't have to say there was a breach of the warranty of habitability. If you say I didn't have water, the court's should construe that as liberally as possible. You still are subject as a tenant. You still have to provide proper notice. No more bond requirements. You don't have to post a bond to use this defense. You don't have to have accrued any expense. You don't have to use any other remedy in response to the breach to use this as a defense. If it is raised as a defense, the court shall order the landlord or the tenant to provide documentation relevant to that breach that either party requests at least 96 hours before the day of trial. This is one of the first hard timelines we've gotten on discovery in an eviction case. Documentation includes records, notices, reports, correspondence, other documentation. If the landlord fails to provide all relevant documentation, the court's going to continue that case. And repeated failure may be good cause for appropriate sanctions against the landlord. The court may also limit or exclude a document if the party fails to provide them without good cause, and the delay in providing documentation would substantially prejudice the opposing party. It's a defense against non-payment. This is very large. I'm sorry, we're just not going to get to questions. I'm real sorry. There's a whole lot more information. So the defense for a breach of the warranty of habitability is a defense against non-payment in an eviction case if the tenant can establish that within 60 days before or at any time during the period in which the tenant is alleged to owe rent or any other monetary amount due pursuant to the rental agreement. That's the defense. 60 days before, any time during the period of non-payment, or at any time during the tenancy and the uninhabitable condition continue to exist into the period in which the tenant is alleged to owe rent or the monetary amount due pursuant to the rental agreement. Does not need to prove at hearing that the uninhabitable condition still exists. It's now a defense for non-money cases. Got to show that the non-monetary lease violation primarily arose from the breach of the warranty of habitability. It is not a defense if the landlord proves the tenant committed a substantial violation. All right, if you prove the affirmative defense of the breach of the warranty of habitability, the court shall deny possession to the landlord, deem the tenant prevailing party, order and payment of rent as determined by the court within 30 days. That used to be 14 days. It's now jumped up to 30 days. They also have to, the court has to order the landlord to fix any uninhabitable condition within a specific frame. This order may include continuing any ongoing remedial action, compliance with any obligations for habitability, specific performance, injunctive relief, or other relief deemed necessary. Order a reduction in rent backdated to when the uninhabitability began until the condition is fixed. Order the landlord to reimburse the tenant any difference in the rent paid and the reduced rent amount. Determine and award actual damages to the tenant, but the tenant may continue the case for a final determination on what the actual damages will be. Award the tenant costs and attorney fees. Determine whether the landlord has proven that any outstanding rent is owed after considering the reduction in the rent and also deducting any other expenses incurred by the tenant or actual damages, deducting attorney fees, deducting court costs, deducting monetary damages from separate counterclaims asserted and prevailed on by the tenant. Easy example here to draw on. If you've got a warranty of habitability breach and you've got illegal late fees, those illegal late fee counterclaims are then going to be deducted from the rent. If the tenant asserts this defense but does not prove the case, if a land on a non-payment case, the court shall provide the tenant with 14 days to pay the landlord or the court the rent that is owed. If the tenant pays the amount ordered, then the court shall dismiss the case with prejudice. If the tenant fails to pay within that 14-day period, then the court may enter the judgment for possession. The court determined that the tenant raised the defense frivolously or for the purpose of delay. There will be no 14-day waiting period. There will be no 14-day grace period to be able to repay the rent. If you assert in good faith that there was a breach of the warranty of habitability, then the court will provide you with grace, that 14-day grace period to get caught up on rent. If you were not acting in good faith, the court will not provide you with that grace period. Fair market rental value for an uninhabitable dwelling, rebuttable presumption. It's our old friend, the presumption. So if a court or a jury finds a breach of the warranty of habitability, then the fair market value of the property is, if it's life, health, or safety, $0. Nothing. Yeah, because it materially interferes with your life, health, or safety, right? If it is by statute, not one of those, 50%. Attorney fees in a breach. If a rental agreement allows the prevailing party to seek attorney fees and the court determines a prevailing party for an action brought pursuant to the warranty of habitability, then that party may also recover reasonable attorney fees. Landlords may only cover reasonable attorney fees if the court finds that the tenant filed a frivolous complaint or frivolous counterclaim under the warranty of habitability. Prohibited lease clause, you can't modify or waive any right related to the warranty of habitability. This includes any provision that charges a cost, fee, or penalty to a tenant because the tenant attempted to exercise its rights. You can exercise more than one right. Landlord's defense against the claim of a breach of the warranty of habitability. So landlords can defend against this claim. To do that, you must show that the tenant refused to provide or accept a proposed reasonable alternative date and time for entry into the dwelling, unreasonably denied entry into the unit, or engaged in any other inaction that delayed, prevented the landlord from fixing the problem. And the tenant's actions made it impracticable for the landlord to reasonably repair or remedy the condition. Retaliation. Shall not retaliate for making good faith complaint, organizing, or exercising or attempting to exercise in good faith. Sorry, food faith, any right or remedy afforded to a tenant. All right, retaliation includes increasing rent, decreasing services, terminating or not renewing a rental agreement, bringing or threatening to bring an eviction action, taking action that in any manner intimidates, threatens, discriminates against, harasses, retaliates against a tenant, charging the tenant or seeking to collect from the tenant any fee, cost, penalty. Retaliation as a defense. It is a defense against an eviction based on non-payment, a notice to quit, to terminate a tenancy, expiration of a rental agreement, non-payment of rent resulting from a retaliatory rent increase. To prove the defense, the tenant does not need to prove the retaliation was the sole reason, the only reason, but you need to demonstrate that the protected activity was a motivating factor that influenced the decision. If a landlord retaliates, then a tenant shall recover damages in amount not more than 3 times the tenant's rent or actual damages, whichever is greater, plus attorney fees, and the tenant may terminate the rental agreement. All right, we might get to 3 minutes of questions. All right, the Attorney General now has jurisdiction over the warranty of habitability. So the Attorney General may start a civil action against a person that has committed or is engaging in a pattern of violating the warranty of habitability. The Attorney General may intervene by right in a civil action in any court that involves a claim, defense, or counterclaim brought pursuant to the warranty of habitability. When bringing a case or intervening in a case, the Attorney General may prioritize cases in which a person or group of people have engaged in a pattern or practice of resistance to or non-compliance with the warranty of habitability, or a person who violated the warranty of habitability or has denied a person any right protection, and such denial violation raises an issue of public importance. The Attorney General may also try to get a temporary restraining order, an injunction, or both. They may also accept an assurance that the practice will stop. Civil penalties when the Attorney General gets involved. You can $20,000 for each violation of the warranty of habitability. Civil penalty of not more than $10,000 for each violation of a court order or an injunction. These penalties then go into the Colorado's general fund. I've hit the end of my slides. Yeah, sure. We've got 11 minutes. I'm gonna go around the room. One question per person. Make it count. By 7?
Yeah, we have to.
All right. All right, 5 or 6 minutes. All right, hands up, pick your best question. Go. I can't give legal advice. You've got to apply. ColoradoLegalServices.org. You can call this number right here. All right. You can apply online. You can apply in person. You can apply over the phone. On Wednesday nights, you can also utilize the Justice Center's Call a Lawyer. That's from 7 to 8:30 on Wednesday nights. Walk-in, not with CLS. You have to apply for services with us first. The walk-in is going to be the Call a Lawyer. That's going to be the closest to a physical walk-in. Yes, sir. That still has not happened. No, it just can't be retaliatory, discriminatory, or unconscionable. Don't shoot the messenger? Yes, ma'am. So our process, if you come in to apply, we'll take the application. One of our support staff will follow up to conduct an interview. And then we have kind of a rolling case staffing where we staff cases to see, and they are accepted by attorney availability. If you call in and you call into our statewide intake system, you may be able to speak with somebody that day. Oh, of course. I'm going to check. I don't see any other hands up right now. So, I see one right here. Address 102 South Tejon Street, Suite 430. If there's an issue with applicable building, housing, or health codes, it may be, but it's a little too vague. And to get more details, then you're going to get me into the, you got to apply part because it's too specific at that point. So it's maybe is the answer, but it's not. The garage was not previously in there.
Right, I mean, the exits, like the fact that the doors all, you can get out, but the garage is, what about, if there's a thing about a coat, how they have coats like for dryer vents and all that, what if it's older premises and the dryer vents not up to code where
Contact, if it's not, well,
it goes into
if it's,
the garage.
so I gotta play a little bit of semantics with you. The question was about what if you have an appliance that is not up to code? Code enforcement is enforced. Code relates to minimum city building standards, not the warranty of habitability. There's overlap, but code enforcement does not enforce the warranty of habitability. Courts do. But if code enforcement finds a violation of code and they provide that notice to the landlord, that would be a written notice from a governmental entity regarding an uninhabitable condition potentially. Because if we're dealing with a dryer, then we have a potential for fire.
Thank you.
Thank you, everyone.